Sources of Special Education Law, a timeline of legislation impacting students with disabilities. 1954, Brown versus the Board of Education of Topeka. This case declared that separate facilities for students of different races were inherently unequal, and racial segregation was ruled a violation of the Equal Protection Clause of the 14th Amendment of the Constitution. While this case would, and still is, used to combat racial inequality, it also paved the way for students with disabilities to receive equal access in schools. 1973, Section 504 of the Americans with Disabilities Act. Section 504 made it illegal for programs receiving federal funding to discriminate or exclude people with disabilities. This meant that otherwise qualified person could not be passed over or fired from a job because of a permanent or temporary disability. Employers and schools are now required to make accommodations to meet the needs of students and employees. 1975, the Education for All Handicapped Children Act. Before 1975, schools were not required to provide education to students with disabilities, and in some states there were laws actively banning them. Some states provided special schools, sometimes several miles away, but neighborhood schools, called mainstreaming by parents, could choose whether or not to enroll students with disabilities. Through the hard work and persistence of parents, the Education for All Handicapped Children Act was passed. This act revolutionized how children with disabilities were educated and treated in the United States. Students now had the right to a free and appropriate education in their least restrictive environment. This meant they had the right to attend their local schools and live at home instead of being sent to institutions or schools far away. This act also resulted in the creation of the procedural safeguards. The Education for All Handicapped Children Act also increased the amount of participation and input parents had in their students' education. 1982, Board of Education versus Rowley. This case centered around a deaf student named Amy Rowley. When she began kindergarten at her local school, she was given an FM hearing aid but had no sign language interpreter. Her parents felt that she would do better academically if the school provided an interpreter for her, but the school argued that she did not need one. Tests conducted with and without an interpreter proved her parents to be right. However, the courts ruled in favor of the school. This case went all the way to the Supreme Court, who ruled 6-3 that under the Education for All Handicapped Children Act, Amy was only entitled to a free and appropriate public education, not an above-average one. 1986, Education for All Handicapped Children Act, reauthorization. In 1986, the Education for All Handicapped Children Act was reauthorized and updated. Along with this update came the inclusion of early intervention. This meant that children ages 3 to 5 with disabilities or developmental delays could begin receiving services before they reached school age. Additionally, states could receive funding to serve children birth to 2 years old who had certain conditions that might result in disability or developmental delay. 1990, Individuals with Disabilities Education Act. In 1990, the Education for All Handicapped Children Act was reauthorized again and was renamed the Individuals with Disabilities Education Act to emphasize person-first language. IDEA also redefined the categories of eligibility, placing autism and traumatic brain injury in their own section. Individuals with Disabilities Education Act also added a transition plan stating at the age of 16 at their annual IEP, students with disabilities, along with their teachers and parents, would begin planning the student's future outside of high school. 1997, Individuals with Disabilities Education Act, reauthorization. In 1997, IDEA was reauthorized, and again changes were made to improve and clarify the law. Eligibility and IEP requirements were increased to prevent students from being misdiagnosed as having a disability, and amendments were made to treat behavior as an educational issue. This meant that students engaging in dangerous or destructive behavior were held to a high standard of accountability, regardless of disability, in order to protect the safety of all students. 2004, Individuals with Disabilities Education Improvement Act. In 2004, the most recent authorization of IDEA was passed. This was called the Individuals with Disabilities Education Improvement Act, or IDEA 04. The Individuals with Disabilities Education Improvement Act clarified and defined what No Child Left Behind's highly qualified meant for special education teachers. The procedural safeguards for parents were once again updated and clarified. 2017, Andrew F. versus Douglas County School District. This case centered around Andrew F., a child with autism, whose parents removed him from public school after due process because they felt he was not being appropriately challenged. The U.S. Supreme Court overturned the 10th Circuit Court's ruling and found that, quote, every child should have the chance to meet challenging objectives, close quote. This case was significant because it focuses efforts of both parents and teachers on meaningful achievement for students with disabilities and requires IEPs to be written so as to encourage ambitious academic progress for all students.